95.3 WDXE.
WDXE, that's us. And speaking of the good us, Stan Pierchoski's in here this morning. It's Friday, so it's Stan Pierchoski with Pierchoski Law, and located in Pulaski, Tennessee. And we do everything estate planning wise. That's right, estate plan Stan.
Good morning, Jeff. Yes, this is bulletproof estate planning, we call it.
That's right.
With estate plan Stan.
That's right. Well, it's been a whole week, so what have you been up to?
It has been a whole week. Well, had one of my main people out on vacation. They decided to go to Disney World for a week, and we have to operate things a little differently because she's kind of an instrumental person. But no big deal. I mean, they get their time off. They have to decompress too. So
I've never been to Disney World.
I guess I probably shouldn't say this, but when the kids were little, I've been to Disney World several times. I went a couple of times before I even got married, and so I took the kids when they were little to Disney World. But about 15 years or so ago, maybe 20, I made the decision I don't ever want to go there again, ever. And everybody raves about Epcot, and I thought I've been to Epcot once or twice, and I thought, geez, I think this thing it's just so boring to me. Yeah. And the other stuff, anyway. So I haven't gone. I just refused to go, and there was no reason. The kids weren't little anymore and stuff like that. So, but last September, as a matter of fact, I do this every year. I treat my entire staff to vacation.
Okay.
And we all go together.
Yes.
And let them vote on where they want to go. Guess where they voted?
They want to go to Disney.
Yeah. So I went to the parks one day, and they went to the parks like 3 days, but I found something else to do on the other two. But I mean, it was.
Well, it's fun to be on vacation anyway.
It is.
Almost no matter where you are.
It is. It's just, when I go I don't like the hecticness when you go on vacation. And that place is very organized. There's no doubt about that. But it is very hectic. I mean, there's just, I don't wait in line very well anymore like I used to.
Yeah.
And those lines give a whole new definition to the word waiting in line. It's like, are you kidding me?
I am sure.
But anyway.
So good week. You had a good week?
Yeah. It was a good week. Good week, and some issues came up, stuff like that. It's always putting out a couple of fires here and there, but
sure.
We had a glitch with a 10-care application that we're backing up and resolving. Had a death that was unexpected, of a client. And just stuff that happens.
Life happens,
and it's the stuff we plan around. That's what we're planning for.
Life happens, and the smart ones plan for events.
It happens
for the unplanned.
And it happens, and sometimes it just plain gets in the way.
And that's what leading up to you and what you do. Planning for the unplanned is a good way to think about it.
I often tell people I'm in the what if business. I can what if stuff better than anybody. So
I was thinking about, and you may have a direction you want to go this morning, but I was thinking about something I wanted to ask you, even from last week.
I remember, and I was going to remind you of that.
Even from last week, I thought about it.
But before we do, let's give folks the telephone number and say it, because remember, this is a call-in show.
That's right.
For people to, ask me a question. Use my time if you want it. So if you want to call and ask me a question about anything or a follow-up question on what Jeff is about to ask, it's 931-766-9393. Call in and he will answer the phone.
That is correct. I was thinking about, the time, and of course, I know you have your seminars, which is probably the best way to start. You just got finished with one. But I'm thinking, okay, if I want to start some type of estate planning, and maybe think about the idea of having a trust and all that kind of stuff. What information do I need with me when we come and do like the get started visit?
Right.
What information would one need about their belongings? About what kind of things would we need to prepare for to sit down with you and really begin to plan our trust or our estate?
Not a bad question. We have a workbook that we provide people, and it gives us the basic information for drafting these trusts. And I do all my own drafting. But here's a good way to think of it. If you think about what like a trust plan does, I mean, it distributes property after death. Okay?
Right.
It's a plan for It also is a plan for during life, as far as incapacity, possibly. If maybe something happened to you where you can't make decisions anymore, but you're still alive. Okay?
Yes.
So that's what we call incapacity planning. And so in order to accomplish those goals, there's certain things that we need. And so when you come to see me, one of the things you have to explain to me that I can't do for you is you have to tell me what I call the distribution scheme is of your property. Like, what do you have in mind for how your stuff's going to go? And so I often tell people the best way to answer that and explain it to me is fast forward to that point and tell me what the ideal result is to you. You know, it's like, okay, if I were to pass away, I would like my property to stay in the family. My real estate, you know, especially the acreage and the farm or whatever, the family farm or the family homestead. I'd like that to stay with somebody in the family or whatever. And I'd like I have a child doesn't live here anymore. I'd like them to get a certain amount of funds, liquid funds, because I know they wouldn't be interested in the land here, you know, that sort of thing. Stuff like that. And people have all different ideas of what they want. I mean, it's a very personal thing. Everybody's different. So and then explain to me what your ideal result is, and I can back it up and put it in the trust to make that work. So that's something you have to provide to me because I don't know what you want to do with your property. Now, the other information I need is the players in this plan. You know, everything you do has what we call fiduciaries. So, like if you have a power of attorney document, you're naming someone called your agent. Or sometimes they call them an attorney in fact, but the person you're naming to act for you. And if in a trust, somebody's got to pick up, you know, usually most folks are trustee during their trust during life, but after death, we have what is called the successor trustee. You have to name who's going to have the authority to distribute all this property in accordance with what I said in my trust. And that's a successor trustee. And then we have other documents where we name fiduciaries. So you also want to think about naming more than one, because you don't want to run out. In other words, if you have a power of attorney and you just name my spouse and she predeceases you and then something happens, you need your power of attorney, now you don't have one. And if you don't have one, the only remedy, and if you lose the ability to name one, you know, in other words, if you don't have one and you're still of sound mind, you can do a new power of attorney, real easy. But if something happens and you're incapacitated and your spouse is predeceased and there's nobody named after that person, now you don't have one. And the only way to fill that gap is to go to court and get a conservatorship. And so that court's the whole thing we try to avoid, really. So when you name your fiduciaries, it's nice to name at least 2. 3 is better, like in consecutive order. Like I'll say, I'll name my spouse first, but if she predeceases me, I want my daughter.
Yes.
And if she's unable or unwilling, and the language I use is unable or unwilling to perform, which covers just about everything. And then if not, then it goes to my son. You know, and that way, I'm pretty sure by the time you get to the third one, it's getting pretty remote. So I'm not gonna run out.
Yeah.
That you have to provide
That's
to me who those people are. And some people say, well, can they act together? And he says, we went over this one day on the station here. Yeah, you can act together. They can act in a consecutive order where one person's in power at any given point, or they can act jointly. If they act jointly, we got to ask the question: are they going to act with unanimous decision or independent authority? You know, stuff like that.
Right.
But you can, there's all kind of ways that can happen. So the fiduciaries you need, and we'll talk about that as to who the better picks are for stuff like that. Also, you have to give me a rough understanding of what your property is, because we talk about how to put it into the trust. So real estate is something we always put in trust, and I do that for people. So in my workbook, you identify the real estate that you own.
Sure.
I pull the property records and draft the new deeds. Okay. They're deeding it to the trustee. You put it in trust. Things like bank accounts. I've said several times, I tell people, we definitely want to put, like in our revocable living trust, we definitely want to put our bank accounts or whatever we have with financial institutions into the trust, because we want everything that's in the trust will avoid a probate process.
Yes.
And so we want everything in there. Now, I cannot put a bank account in the trust for you, because the bank account, it's personal property, but you have a contract with somebody.
Yes.
And that contract doesn't involve me. So I'm not involved in the contract. So I can't go to the bank and say, hey, I want to sign over Jeff Hood's bank account into his trust. I mean, they're going to question my authority and I won't have it.
Yeah, exactly,
okay?
exactly.
But we talk about that, and I say, okay, here's what you have to do. And if you need my help, I'm available. But you go to the bank, you tell them, hey, I did one of Mr. Stan's trust. I want to change it, the ownership of the account from me, Jeff Hood, to me, Jeff Hood, the trustee of my trust. Banks know what to do.
They know what to do.
They're no strangers to trust
Yes.
law. Almost every bank has a trust department. And so they get it. But they'll want to look at something. It's called a certificate of trust, which our legislature created a statute that says anybody that wants to prove the existence of a trust can't go look at the trust and all the personal information, but they are entitled to certain pieces of information that are not personal. And so we draft a certificate of trust with everyone, and we sit there and talk about it. And I say, this is what the bank will ask for.
Yes.
And when they say, okay, what do you want the new owner to look like? And it's right there in that certificate of trust. The new owner, instead of being Jeff Hood, is now going to be Jeff Hood, trustee of the Jeff Hood Living Trust, okay. Something along those lines.
Okay.
And that's how the assets are titled. So, I don't need a real in-depth analysis for your finances. Like, in other words, you don't have to give me your bank accounts and tell me how much is in it. It's not so much that I need to know how much you own, and even then, the only time it's how much you own is even relevant is if we're looking to see if we have a taxable estate.
Yes.
And don't get too many of those around here. I mean, it's just the way it is. I mean, the federal estate allotment is $12.9 million per person, or twice that for a married couple. If you exceed, if you're over that, it's a heavy taxation that there's planning techniques we can use to avoid that. But for the most part, 95 or 99% of my clients are in southern middle Tennessee, are just most, regular folks that, have pretty good estates, but, usually not in the taxable range. So I don't need to know.
Yeah,
I don't need to know.
I'm probably not going to make the taxable rate there. So.
I don't need to know amounts necessarily, just enough to know that it's taxable or not taxable. Because if it is taxable, we need to do something,
right?
Because it's a 40% tax for every dollar over that cap, right. So it's pretty heavy. But it doesn't happen often. So we get a lot of this information, and then that's pretty much. The other thing that I need to know is when in this distribution scheme, like when you want to leave your property to your children, most people. And I don't mean this the way it sounds, but most people there's some issues with the kids or with whoever the heirs are.
Sure.
Issues like, I love my kids, but the one just spends money like water, and I don't want my inheritance to get blown on a jacked up truck, Yeah. I mean, I have one of those, okay?
Yeah.
Or let me put it this way. I used to have one of those.
Okay.
The light finally went off about 5-6 years ago, and
Yeah.
that's completely gone. But at the time when I was putting together my own plan, it was a concern,
Sure.
Because I'm thinking, okay, if I leave some assets to my kids, I want it to go be a good start on something, like maybe an education if they don't have one already, maybe the down payment on a new home, because that kind of cripples young couples, right? I mean, it's very expensive. Or I got a couple entrepreneurs in the family, and I don't doubt one day they'll have their own business, and it might help start something like that. That's what I have in mind to use it, not just big party, jacked up truck, stuff like that. I really don't think that's a good idea, because I want it to be there to help. I don't want it to be there just for a luxury thing. That's my. Now, some people say, I just want to leave it to them. If they can use it for whatever they want. I'm going to leave it entirely up to them.
Right.
That's what I meant by this is very personal. If that's okay with you, then that's what we do.
Sure.
But my thought process is a little bit different. Now, if you have a problem with a child like that, or unfortunately what we see a lot of is you got an adult child that has a drug problem.
Yeah.
And now that's a real.
It is
that's
a real issue. Yeah, it's a real
because
issue.
when you think about this, if you don't make a trust, and you just want to make a will or no will at all, this child is going to end up with with his share of money.
Yeah.
Or whatever it is, it's going to be property.
Right.
And when he gets it, it's going to be what we call an outright distribution. He's going to come to him, and he's going to be his, and that's the end of it. Ownership is complete. Now, if you have a drug habit, when you come into money, we pretty much can figure out what's going to happen to that money.
Yeah.
And unfortunately, you could end up being the instrument of their destruction. I mean, you can see the logic.
Sure.
I've seen it, and I've seen it till I'm sick of seeing it.
It's not a fun thing to think about for anybody that's in that circumstance.
Now,
no doubt.
What's the alternative? Disinherit them?
Yeah.
And so, I mean, okay. If I'm going to leave them some money, but if they're just going to use it on their drug habit, then I'm not going to leave them any.
Right.
So you don't have very good options there. Neither one is very desirable. It's like I love my child. I don't love what they do.
Right.
But I love my child, and I would rather that the money go to support him or help him or get past this issue.
Exactly.
And there's several. I use drugs because it's something we see a lot.
Yeah.
Okay. But you get the idea. If something's going on that you want to protect them from. Now, that's where a trust plan really shines, because you can put terms and conditions on the inheritance. You cannot do that through the will and the probate process.
Okay.
And so you leave it to them in trust, and you put the protections on it and say, here's this money, but basically, in the simplistic form, we prevent it from being used for any drug or alcohol kind of issues, but it could be used for rehabilitation, education,
Yes.
necessities, medical expense, stuff like that. We do that by putting somebody else in control of it or in co-control of it.
Right.
So those are the things the information that we need. And I have this meeting I call it a family vision meeting. When I'm at my seminars, I talk about it at the end and say, all this begins with a family vision meeting. And this vision meeting is basically about 2 hours long. Like sometimes maybe an hour and a half, but it's a pretty long meeting. And that's where we do a deep dive into your family dynamics. We try to uncover what you're worried about. Because that's why I'm talking about fast forward to the end and give me the ideal result. And,
Yes.
and you fast forward to the end, you think, I got this child, and he's got this drug habit, and he's just, I'm worried if he has that when I pass away, he's going to kill himself with my inheritance.
Yeah.
So let's look at what's the ideal result. The ideal result is say I want to leave him his share of the inheritance, but I want to be protected from that habit. Okay,
Yeah.
That's what I need to know to back it up, and say, okay, how about we're going to do instead of just leaving it to him, we're going to leave it to him in trust, and we're going to make somebody else, his brother, his sister, or him and his brother, trustees or co-trustees over this trust. And now we have a check and balance system on the stuff that's coming out and going to this child
Right.
to make sure it's going for purposes that are okay and not for purposes that aren't okay. And then we can also put in self-exacting language that says, hey, if the other trustee says, hey, there's been a term of 5 years, no drug or alcohol issues, everything looks good, the self-exacting language can say, now the child can be the sole trustee of his own trust because the problem we were trying to solve no longer exists.
Right.
And so
It strikes me that these can be tough conversations to have, but if you'll go through the work and do this, then there would be some peace of mind behind that.
Oh, a ton of it, because and another thing is when you have special needs children. These are the things that wake people up in the middle of the night. What's
Yeah.
going to happen to these people with these problems or the special needs child or something if I'm not here to do what I do every day?
Right.
So that's a real issue, and that's what the whole process is about. And sometimes it's difficult,
Yeah.
and I get it, and I try to be sympathetic. But the only way to deal with it is to deal with it.
Yeah.
You have to embrace it, hit it head on, because you will feel 200% better if you start down a solution path for these problems.
That's what I'm saying. The peace of mind that would come with the end of having all these questions answered and a plan to resolve them in the event, and when the inevitable does happen, then you've got a plan in place.
In one of the earlier shows when we started this, I think I talked a lot about myself, and I talked about when I got into this business, and I said that I get thank you notes from my trust clients these days. When I used to do criminal defense work, I didn't get too many of those, but I get thank you notes. I get some of the women bring me cookies, and I got a guy that brings me bottles of CBD oil every now and then. I'm just. And it's because the response I get when we put these trust plans together, a lot of people tell me, and they'll give me a hug and say that just a tremendous weight off their shoulders.
I can see
They've
that.
got something done.
Yeah.
And some people I've had some people tell me, I have been fretting about this for 2 years.
Yeah.
And their spouse is there, and they say, look, you've been worried about this, talking about it for 2 years now. And now they're finally got something that they know. It's a plan that'll work for a couple of reasons. One, I don't make plans that don't work. And two, it's well thought out, it's well formulated, it's founded in our trust code. It's all the things I talk about that we make it work.
Yeah.
And I've seen,
Yeah.
I've had enough trust of mine that mature, which means the makers of the trust have passed on, and now the trust has to be administered. And I've seen them work, and they work like a well-oiled machine. Every now and then there's a glitch. But usually the glitch is you got a disgruntled heir. You got somebody that they kind of disinherited,
Yeah.
and now they're not happy about
Someone
that.
that wants to fight it.
Now
or
it
something.
doesn't. They're rarely successful, but they
Yeah.
they pitch a fit and throw a monkey wrench in things. But so the answer to the question is what needs to be done. Not a whole lot. It's sort of a process.
Right.
And I give this workbook, and the workbook just has basic information. It's not very
Yeah.
difficult to fill
Yeah.
out. But that's kind of what we sit down and talk about. We kind of say, because we kind of start off with what's the end result.
Yes.
That tells me where all the issues are, what the concerns are, where the problems that need to be solved are, and then we start talking about those options. Okay.
Right.
Okay. And I'll help you with those options. Someone will say, well, I'd like to I want to make sure my property goes to my daughter, but I want to make sure if she ever gets divorced, from her no-count husband, or something. You know, I don't want him walking away with half her inheritance, right? And you know what? When somebody says that, that tells me exactly what I need to know.
Yes.
I say, okay, I got you. You want to leave it to your daughter. You want her to have it. You have a concern about this third-party interference going on. I don't know if it, because you know how it is when you have a child that gets married. It's like, if they were just themselves, they would be financially responsible and they do probably what you want.
Yeah.
But when they get married, now they're in a rock and a hard spot. Because let's say this daughter has her husband who's saying, hey, you got this inheritance. I'm trying to make this business here work and it's failing. I need some of your dad's money to.
Yeah.
And now here's your daughter. She's got the love for dad and wants to do what he wants, but she also is burdened with keeping the marriage happy.
Yeah.
And she's under some influence, you know, to do one thing or the other. That's the what if you can't control. So people say, I want this to go, no matter what, I want this going to my daughter and not available to my in-law.
Wow.
I get that request a lot.
Really?
And so that's a simple fix. But I mean, once you tell me that, that tells me 100% of what I need to know. Now we just start talking about the logistics of doing that. And I say, okay, you know, let's talk about she can use it for, or what she absolutely isn't. You don't want her to use it for.
Right.
I just don't want her to give it to him or use it for anything of his expenses.
One of those crazy ideas that your son-in-law has.
Yeah. Well, here's a good example. Had a couple that, a parent came in and they had got their child got married.
Yeah.
And there was a large school debt, a school loan debt.
Oh yeah. Okay.
And between them, they had pretty much decided that he was going to chip away at that pretty much. I mean, I think it was decided that, hey, the daughter said, hey, this is my husband. I'm going to help him with his debt. But the husband was pretty magnanimous about it and said, no, this is my debt, and I'm gonna chip away at it myself. And so one of the things we want to do is say, I want to leave inheritance to my daughter, but one of the prohibited uses of it is to put it toward his school debt if there's anything there at my death.
Yeah.
Now, the person asked me, they said, what if, later on I changed my mind. Suppose my son-in-law hits this debt hard and he's paying it off. He's really trying to get it. I mean, really doing it. You look at him and say, God bless him. He's doing what he says he's going to do. He's chipping away at it.
Sure.
And I changed my mind. And I think, you know what? That tells me a lot about that son-in-law.
Yeah.
And if I pass away and there's some still debt there, I would like to help with that. Can I change that? And he said, absolutely. We can put that language in. So you kind of see what I'm talking about when I say, tell me what you want, and we'll work out the details. That's my job, is to work out how to make it work, and we can. So we can put that kind of language in there, and you can look at it and say, and sometimes if it's complicated, I'll say, look, let me take a shot at it. You read what I've written, and tell me if I've captured what you want. So, and then back and forth a time or two, we hone in on it.
Sure.
Most folks just say, kind of like to leave my kids a third each, or whatever. And some people don't like to get too complicated with it. But others who have issues almost need to, in a way. And I don't know, it's always a good idea these days to just say, you know what, I'm going to give it to them. I'll be gone. They can just do whatever they want. If they want to blow it, they can blow it. I get that logic.
Yeah.
I get it.
They just don't want to worry about it.
But I've had some trust clients that came in and said, I'm going to put some strict rules in mine because I inherited a bunch of money from my mother. And I partied and blew it all. And now I have a life where I struggle. I have to hold two jobs.
Yeah.
And I sure could be using that if I'd have been smart the first time. I said, there's no way my kids are going to do what I did. So I'm protecting it for them. And when you do all this, you may make somebody mad. Like this, say you got the drug addiction, right?
Yeah.
And the person can't get at the money. And they're probably going to be ticked, right?
I would imagine so.
And of course, it's the addiction talking, but they're not going to be happy.
Right.
But here's what you take comfort in. I guarantee you are doing them a favor by doing it that way. You really are. And I've had people that get on the other side of what their issues are, and they say that. They say, I'm so glad that they left it to me that way because I would have blown through it.
Yeah.
And that's no good. I mean, It's kind of like winning the lottery and then a year later being broke. I mean, what a shame to get that opportunity to stay ahead financially for the rest of your life.
Yes.
If you just are a good steward with it and don't get crazy.
Right.
And then,
exactly.
and then in the year, you're in the same boat. Well, maybe you got a nice new vehicle and something else, but you could set yourself up,
Yeah.
not to do nothing for the rest of your life, but you know what I mean. You have this security forever.
Right. we are hearing we got some construction going on outside the doors out there.
Those noises are not coming from you or me.
We've got some more studio remodeling going on. So anyways, I apologize for the noise there. But good information this morning.
Yeah.
That's really good information. I had thought about that, and I thought, and of course, I wondered, if before, sitting down with you, and of course, I know you go through this with your seminars, and of course, I get the benefit of kind of having my own personal seminars here with you on Fridays. So that's pretty good. So that's why I've got some questions. But I'm thinking, well, if I did, get to the point where we're ready to put all this together, I would need to kind of take some kind of inventory of our belongings.
Well, and you don't need to do inventory of everything for me.
Sure.
The trust plan, but it is a good idea to do that.
Yeah.
I mean, insurance purposes,
Yeah.
photographs. Now, that brings up an interesting question. When you talk about your belongings, you're sort of talking about what I call your stuff.
Yeah. I'm talking about all of our assets. You know, all the things that belong to us.
Now, that's always a good plan because if something happens to you,
Yeah.
and your kids don't know what you own, I don't know that people appreciate the spot they put them in. It's like, if I don't know what one of your children says, I don't know what my dad owns.
Yeah.
So what do I do? Just start calling banks and say, hey, does my dad have a checking account with you here? Or
I have no idea.
I guess one of the things to do is you can wait and see what kind of mail trickles in and see who's sending stuff.
Yeah, there's some of that.
That's a way.
And hey, that happens.
It does.
It happens all the time.
And we've had stuff get missed. We find that in TennCare a lot. Okay, it blows my mind sometimes. We gather everything, we start the process, and of course TennCare will always ask questions before they approve about this and that.
Right.
And every once in a while, maybe even more than once in a while, they will call and say, "Hey, what about this? What about this CD that I found your applicant's name on?" And I'm thinking, okay, what the heck are you talking about? So I go to the family and they go, "I don't know what you're talking about. I didn't know." And Gertrude had this CD, and we have no clue what they're talking about. But TennCare found it. We're thinking, okay, now what? So we have to hurry up and search and find it. And I had one like that where it turned out that, this was, the gal worked for the church, and they had these, I think it were like CDs, and her name was on it because she worked for the church and had to deal with it, but she was not a beneficiary. So she didn't have any value in it. Once we found out, we disclosed it, TennCare's like, oh, okay, so there's no countable asset there. She just was like a fiduciary on it. So that's right. And we had to show the documentation. We got an affidavit from the guy that worked at the church at the time,
right,
and stuff. But they brought this thing up, and nobody knew the person had it. Was even involved in it. So that if you're doing your kids a favor, and it's just good for you too to just get everything organized and gather everything. And actually in our trust books, we have these asset sheets that you can list stuff that you have. And some people come and do a trust plan, and we look at the bank accounts, and they got 5 or 6 of them. And I'll ask, do you need all these? I mean, if there's a purpose for a separate account, that's fine.
Right.
But I said, no, we moved here from Florida, and I got these 2 accounts down there, and they're still there, and you only got $500 in them and stuff. It's a good time to consolidate and say, you know what, if you don't need it, don't have it.
Right, exactly.
But if you need it for all, some people say, I want to keep this because it's my co-op account. When I go to the co-op, I always use this particular money.
Right.
And that's cool. I mean, if you've got a purpose for it, then leave it. But if you can tone it down and, a couple things less to worry about, really.
Right.
Consolidate. So now another question that people get along the lines of what you kind of just asked me is, what if we do this, what kind of time commitment on my part is it?
That's
what I mean?
Yeah.
And I can go through the whole process and give you an idea. So let's just say you start with a seminar. That's a good place to start.
Mm-hmm.
That takes about an hour. An hour and 15 minutes. Most people are there close to 2 hours because we have a nice Q&A at the end.
Sure.
And, it's pretty informal. But, let's say an hour for the seminar. Then if you decide, hey, I like what you're talking about. I want to have a family vision meeting. That can take up to 2 hours. And we talk and design. That's where we design everything. Then things get put off for about 2 or 3 weeks, or maybe 4 sometimes, for me to draft this thing, because it's a lot of work to draft it, and I have a pipeline of work behind me at any given time.
Sure.
And that's why it takes a couple of weeks, not because of you, but because of my workload. And so then we have a signing date. Now, in between the two, there'll probably be a question or two. I don't know that we could really allot time to that, but then we have a signing where we sit down and put all these documents where we have memorialized them into enforceable instruments, right?
Yes.
And so we sign it. That typically takes a little less than an hour, but we'll say an hour there. So we've got us up to 4 hours now.
Yeah.
And then the only thing left to do is at this signing, I will put everything into the trust that I can put in for you. And that's going to consist of real estate because I can draft the deeds.
Mm-hmm.
And it consists of your stuff, meaning your pots, your pans, your tables, your chairs, all your personal property that does not have title ownership. Okay.
Right.
I can put all that in there for you. What I can't put in for you is a personal property you have that's where you have a contract with a third party, which is usually a financial institution. So that's the bank, that's your checking account, your savings account. If you have CDs, or if you have like an investment account, like a Fidelity or Vanguard kind of thing, those are the things that you have to go to them and say, hey, I did one of Mr. Stan's trust, and I want to move my ownership of this account into that trust. And that's the one where I say I have the documentation. I'll explain to you what they'll ask for, show you this is what they're going to ask for. When they ask for it, send it to them, make a copy, give it to them, and then they'll transfer the ownership for it. If you need my help, I'm always available to help, but I can't do it for you.
Yeah.
But if you want to hold my hand and we go to the bank together, I'll do that. But I can't sign when it comes time to sign for you. So so we help fund the thing on things like that. So maybe another hour or two doing that if you just basically got a bank account or two. Not much time at all. I mean, if you go to the bank and do it, you in and out of there in 15, 20 minutes,
Yeah.
They just draft up the paperwork. Sometimes they'll do it ahead of time. And then, so I don't know, you're looking at what 4 hours with me, essentially, and maybe another hour or two to fund this thing, which this is not all at one time,
Right.
But once you've done this, it's done. It's a one and done. I mean, now your trust is really working for you. If you acquire new property, the question is, well, do I have to come see you and get that put in the trust? The answer is no, not really. Let's think about this. You're in the real estate business, so let's say we put all your real estate that you own right now into your trust.
Right.
2 years from now, the house beside you opens up for sale, or the lot or whatever, and you say, you know what, I'm going to buy this lot so nobody can just build right beside me.
Right.
Okay. And so you buy it. Right? You've already made the decision to buy it, right? So you buy it. So when you get to the closing, you say, look, when you make the deed out, make the deed out to me, Jeff Hood, the trustee of my trust. From the moment of conception, it is in your trust.
That's right.
You don't have to put it in. It goes there because you're going to get a deed anyway, right?
Right, exactly.
Now, if something goes south and you forget, which happens, people call me and say, you know what, I forgot about that. Now it's in my name. And I say, okay, just no problem. Bring it here. We'll do another deed that goes from you to you, the trustee. I mean, we'll get it there, but same thing with the bank account. Let's say your bank has a CD and they're giving some decent interest.
Yeah.
One of these days, maybe that'll happen. You know what I'm saying? And you say, you know what, I'm going to go and put some money in a CD account. Well, you go there, you fill out the paperwork. They're going to want to know who the owner is, and you just write down or tell them, I want the owner of this account to be me, trustee of my trust.
Yes.
And now the moment the account is born, it's in the trust. There's no funding it. There's no putting in the trust. I mean, you're going to do the contract anyway.
Sure.
You're going to say yourself.
Well, at that point, you have a trust established.
Exactly.
So you can place in it what you want
You got a place for it to go.
Right.
I mean, you can tell people, if you're going to leave me an inheritance, leave it to my trust.
Yeah.
Or something like that.
Hey, I want to remind folks that you can call in if you got questions for Stan. 766-9393. 931 number, 931-766-9393. The lines are open. Of course, we're live on Facebook and YouTube and on WDXE here on the radio.
And if you don't like the topic we're on, call in and
we'll change the subject.
Shift gears on us.
We'll change the subject. But interesting. Yeah, that was what I thought about. I thought, okay, what do we need to gather together to get started? That was very good. I enjoyed that.
Let me just touch on these questions of yours, Jeff, because this is why I like questions, and this is why I invite them, and this is why I love the question and answer period at the seminar.
Sure.
This, just in roughly 2 questions or so, and maybe the one that sort of spawned out of it that I just brought up, that you've asked, this tells me what you think about along these lines, what you're concerned about. You think, okay, this sounds interesting. I might like to do this, but what would I have to do to prepare to do this, or what kind of time requirement is going to be to do this? This gives me. So I love it's right where the rubber meets the road, when talking to people. I know what your concerns are. And that works in all the other areas, especially like in TennCare. People call up and say, I've got all this property, I really don't know what can be done. And I call somebody and they tell me, oh, there's just nothing you can do. Don't worry, just be prepared to lose it all. Stuff like that. And so when you tell me that and ask a question, it's like, okay, I see exactly where you are in this process.
Right.
So let's, you feel like there's no options. You have a few people tell you there's no options. listen, if you give me a little bit of time, I'm telling you there really are options. If you
Yes.
want to hear what they are, let's talk about them. And now we can solve this problem, this life experience you're having. We can make it better. You know, that happens in the whole area that we deal with. You know, 10 care or the trust planning.
Yeah.
You know, even writing wills. All the areas that we do, people have concerns. So I mean, and you got to voice them. For me to help answer it, I got to know what it is.
Sure.
And again, don't hesitate. I mean, I offer this time freely because I want to know. I'm not one of those attorneys that charge to talk to me. So if you walk in, people ask me, they come in and say, I got some questions about something. I don't know if I want to do a will or a trust, or I'm worried about Aunt Gertrude in the nursing home. And I said, but you know, if I schedule an appointment with Mr. Stan, is he going to charge me? Now I know some people charge for consultation.
Sure.
I never have, and I never will. And here's why: I'm not going to charge for it. I don't know that I can what I'm going to do for you.
Yeah.
If anything, when people come in and talk to me about estate planning, I know there's usually something I could do for you.
Sure.
Well, it may not be something you want to do, but we'll talk about it.
Sure.
And you have to know these options. And if when you have to pay me is when you say, you know what, I really like this asset protection plan about avoiding the cost of long-term care, and I
Right.
need to do that. And I need to do that. Well, when we do that, that's what my business does. Okay, and then we talk about cost and stuff. But I'm more than happy to discuss it with you.
Sure.
And I get yelled at by my staff all the time because I discuss it too much. And again, this is just my personality, I think. But we offer these 15-minute phone calls, right? I don't think I've ever had one that only lasted 15 minutes. And I get, sometimes they will come in and say, so I have a 10 o'clock phone call, and I'll make the call. And then they'll come in and say, at 10:45, somebody will come in and say, you have an 11 o'clock appointment or another call at 11 o'clock. And
Right.
But I give the time freely, and I don't mind. I know other attorneys might say, well, you're just, undercutting, you're giving advice or you're talking about it and you can bill for that.
Sure.
Maybe I can't. I don't. It's just my I don't know, my Christian beliefs or whatever. I want to help, and I don't. I've had people come in and they say, well, what do I owe you? And I say, well, I don't know that I actually did anything for you. If I didn't do anything for you, then there's no charge. If you came in and we solved the problem and you say, I generated a power of attorney document for you, and we're going to get it signed or something.
Sure.
Okay, that's something we'd bill for. But I don't mind because, and the reason I don't mind is there's so much misinformation in this topic.
Right. Right.
And unfortunately, and I don't mean this to be condescending, but most of what you've heard is not right. And I don't, like I said, I had a show one time here where we talked about it, and I said, if you can just get that open mind and get over that hurdle of what you've heard all this time. Because when you hear it, when that's what you hear, and that's the only thing you hear, you start to believe it. I mean, isn't that what the government and the media do to us?
That's what happens to us all the time.
If you shove their ideas, if they shove their ideas down your throat long enough, you're going to start accepting it. That's the whole philosophical concept of it, right?
It.
Our job is to resist that sort of thing. But anyway, if you hear these things all the time and never hear that there are options, you just start to believe there aren't any. And I'm telling you that there are. And the reason it's a surprise to you is you just haven't heard it yet.
Yeah.
So let's hear it. Have that open mind. Let it come in. Because I had somebody like that I think I talked about not too long ago. They brought their dad in. They said, listen, my dad's just stubborn as a bull.
Oh, boy.
And so they actually got him to come into my office. And that was like an act of Congress to do that, okay? And I started explaining what we can do. And he just kept saying, I've always heard, I talked to this person, they said nothing can be done. I said, well, they're wrong. He said, I read this that said, you can't do this. And I said, well, listen, that's wrong. Would you like me to show you the actual statutory language that shows that we can do that? Now, I don't want to get heavy with legal language.
Yes.
He was very resistant and just had a hard time getting past that.
Once-
I think he will.
Once you get a mindset about something, though, like you become convinced of something, you have to become unconvinced to get past it.
You need to hone on the fact that, hey, if there's a solution out there, maybe we ought to hear what it is. I don't have to do it if I don't want to. And I don't. That's one thing I really pride myself on. You come to my seminars, you have my vision meeting. I'm not here to talk you into anything, and I'm not here to talk you out of anything.
Yeah.
If you hear what I have to say, and you want to do the vision meeting, and we have that. If you decide this is not for you, that's cool. I mean, the good thing about that is that's an informed decision that you made. You say, this is not a good fit for me.
Sure.
Okay, and that's great. You have made that decision, but you made it knowing what the options were. You weighed them and thought, you know what, none of these fit very good, so I don't want to do it.
Yeah.
If it's the opposite, and you say, you know what, I never knew I could do this, but in that house, it's a really good fit for my family because I got a child that's got this problem and I want to protect them, then do it. I mean, you know, I insist that you are part of this decision-making process. Had a client just recently that just kept saying, just tell me where to sign. I said, no, I don't do that. I'm going to explain each document in this plan to you as we go through. It's going to take an hour. He said, I don't want to sit here for an hour and listen to you. Just tell me where to sign. I said, look, if you want that, you can go online and get that all day long. Okay?
Yeah.
I'm going to tell you what these are because if not, I mean, you're going to call me someday and ask me anyway. So
Right.
we do that. So, but I don't like to do business that way. I want you to be involved. So,
Yeah.
and the more you know, the more empowered you feel.
Right.
And you know you're doing something. And if you know something about it, now you know you're doing the right thing.
Sure.
It's not, that sort of thing. You know how it is.
Well, what's happening is you're putting legal documents together.
Yeah.
That have an impact and effect and have power and authority.
Exactly.
So people
Exactly.
need to understand what they're signing. We deal with the same thing with real estate contracts and that kind of thing. And you have buyers who are savvy buyers and buy all the time. You don't have to go over everything with
That's
those
right.
guys.
They get it.
You know, they understand what they're doing. But if you got a new client, someone who's maybe buying their first home or something like that,
Scared to death about
scared
doing
of
it.
you need to go through the process with them and kind of make sure they understand what's happening.
You know, a lot of times I use that as an example, and I tell people when you sign a trust, especially let's take our revocable living trust,
Yeah.
right? I had said before, there's three parties to this agreement.
Yeah.
The trustor, the maker of the trust, the trustee, the person who controls the property, and the beneficiary, which is the person for whom is this drafted to benefit.
Right.
Well, when you do the revocable living trust, you are all three parties.
Right.
So if you ever want to change it, how do you change a contract or an agreement? You get all the parties to agree to the change, right? Well, if you're all
Right.
three parties, shouldn't be a hard thing to do, right?
No.
So I tell people, look, if you want to change this, it's not like you're locked into this 30-year mortgage on your house. Well, if you
Right.
want to change it, you can't just say, you know what, I'm paying $500 a month in this mortgage. It's a little bit tight. I want to start paying $300 a month. Give me some extra spending money. Well, you're not going to get very far unless you get the bank to sign off on that because they are a necessary party to that agreement, right?
Right.
So this is not like that. If you put this together and you think, you know what, I don't like what I did in there. I want to change this. I want to change that. Change it. You can. It's not that
Sure.
kind of contract.
Sure. Absolutely.
Some of the irrevocable trusts have a little bit of things that you have to, once you do it, you have to live with.
Yeah.
But we talk heavily about that.
Yes.
I always tell people, you know, they come in and say, I want that asset protection trust. And I say, okay, well, I'm going to go over a few things here on the whiteboard. They said, well, we saw your presentation and we listened to you on the radio and we know what we want. I said, excellent, but I want to go over a couple things, take about 15, 20 minutes, a couple of things that I want to make sure you know you have to live with this kind of a trust.
Yes.
Make sure. And
Yes.
they're usually always willing to do that.
Sure.
And we do. So, again, this whole process of mine is unique because I want you involved. I'm not a kind of attorney that says, just, you know, make a trust for me and just tell here, sign here. Don't worry about what's in it, just sign the thing. I've decided this is what fits you. I don't do that. If you want that, I'm sure you can find somebody that'll do it for you. But it's not going to be me. I mean, I want you to be involved, and I want you to want this solution.
Well, you know, probably until I've had, you know, several conversations with you, there's been a lot of times that I've been of that mindset. I don't really want to know all the details. Let me just sign that and go. And I've had that mindset about a lot of things, which didn't turn out too well.
Oh, I understand. I've been there myself.
Yeah.
I've been there myself. You know, people say, you know, you have to read everything and read the contract.
Yeah.
That before you sign it. And every one of us has signed something without reading it. I mean,
Yeah.
if not once, many times. And I'm in
Yeah.
the same boat.
Yeah.
I'm in the same boat. And you know, and you would think, no, I don't typically do it, you know, as an attorney, but you know, stuff I'm quasi familiar with. You
Yeah.
know, I know what's in the basic contract. You
Yeah.
know, so I know. Yeah, I'm not trying to bore you with the details. I just want you to, most people want to know what the heck can I do?
Yeah.
And how does that basically work? And that's kind of what we talk about. It's not like a law school lecture for crying out loud. I'm not going to do that.
Right. Right.
But, you know, those details is what you hire me to take care of. But I mean, we talk about what makes the plan work, what it does for you, what it doesn't do for you, how to solve this problem or how to solve that problem. So, you know, that when I say I want you involved, I mean, it's not, like I said, it's not that heavy time requirement. It's just a little bit of foundational knowledge. And then I guarantee you'll feel better about it, knowing what you've done and what what you've got.
I think that's what strikes me about doing this is that the peace of mind that must come after you get this done. It's not necessarily, an easy thing to do, and maybe sometimes you have certain circumstances and situations like you've talked about that are challenging to deal with for families. But if they would deal with them, especially with someone like you who can wade through the matters and ask the right questions, once they get it done, it would be quite the burden lifting thing.
Right. Let me tell you about peace of mind. I had a trust that matured, and when the gentleman was in my office, his oldest son was with him.
Yeah.
And he was involved in the thing. And so we put some details in his trust and how things were supposed to pass.
Right.
And there's some things he was really concerned about.
Yeah.
And it was sort of like he had a couple of children, but only this one was here helping him with the income-producing land that he owned.
Right.
And he wanted to make sure that anyway, he had passed away, and that son came in and said, "You know what?" He said, "I just want to tell you that worked like a well-oiled machine. It worked exactly like Dad wanted it to."
Yeah,
So
that's good.
that peace of mind was there.
Peace of mind. We may be getting a question. Let's see. Good morning. You're on WDXE with us, and Stan Pierchoski.
Yeah, I just wanted to ask him, is it a good idea to go ahead and put the farm and stuff in your kid's name before you die and stuff, or?
Okay, yeah, okay, I get it.
I'm gonna let you We'll hang up and let you listen on the air. Is that okay?
Okay.
All right.
All right, thank you.
Okay, all right. The question is a good idea to put the real estate, the
Yes.
farm, let's say the family farm, into
Right.
a child's name, inter vivos, meaning now during life.
Right.
He said before you die.
Right.
Well, okay, is it a good idea? Well, I'm going to have to say that depends. Okay.
Yeah.
If you want to pass it to them, you can certainly do that. The thing that might not make it such a good idea is what may be the result of that. Now, there's two things to consider when you do that. One, if you're concerned at all about long-term care, in other words, if you have dementia, or it's in the family and you think you're going to get it, or you have a concern that when you do that, you're going to trigger this 5-year period we worry about.
Right.
So if you do it early enough in life, it's probably not much of an issue, because
Right.
if you're before you have any health issues, the 5 years is probably in the bag, right?
Right.
You've got that. It creates a penalty period. So if you are thinking nursing home is in the near future, it is not a good idea.
Right.
Because that will be held against you big time, and it's a problem. Okay.
Yes.
Now the other disadvantage to it is when you give property inter vivos, and real estate's a perfect example. There's a thing called a tax basis.
Mm-hmm.
Okay. And a tax basis, if you don't know what that is, it's basically it's what you paid for it.
Mm-hmm.
And when you give it away during life,
Yes.
the person you're giving it to gets your tax basis.
Mm-hmm.
So what we're dealing with here is capital gain. And I don't want to get too heavy, but let's take an example. Let's say this gentleman that calls has a piece of property, and let's just use nice round numbers,
Okay.
easy to do in your head. And he paid $100,000 for it. So his tax base is $100,000. And let's say he paid that 20 years ago, 30 years ago. Let's say now it's worth, for easy numbers, $200,000.
Yes.
It'd be worth a lot more, but you know what I'm saying, double.
Right.
Well, if he sold it, the gentleman that just called, if he sold it, he would have a $100,000 capital gain because it's a gain above his tax basis.
That's right.
And a capital gains tax is on the gain.
Right.
And that's a pretty healthy percentage, usually about 28.8%, but can be as high as 40.
Right.
Now, when you give it to your kid during life, they get your tax basis. So you've kind of handed him a capital gain liability. So if the child turned around and sold it the next day, he'd have this $100,000 gain that you gave him because he gets your tax basis. And the reason he gets your tax basis is because when you give it to him, there's no bargain for sale or exchange. There's no new tax basis developed. Okay?
Yes.
So that's a problem because you kind of handle them. Now, if you leave it to them after death, like in a trust, the child gets a step up in basis, which means his new tax basis is the fair market value the day of death.
Okay.
So let's say it's $200,000 is what it was worth now,
Right.
and you pass away and you leave it to your son. His tax base is now $200,000. So if he turns around and sells it, if that's the fair market value, there is no gain, right? Now, if he keeps it for 20 years, which is probably what this gentleman has in mind, to leave it with his family, to stay in the family, it will accrue its own capital gain, right?
Right.
But it will have started from the stepped-up basis.
Yeah.
Now, where we see that significant is when you have somebody bought $20,000-$30,000 for a farm that they bought in 40 years ago.
Right.
Now it's worth $2 million.
Yeah.
Or, you know, okay.
Yes.
And
Times and
you
circumstances.
talk about a capital gain.
Yeah.
I mean, you're talking about something healthy, right?
Right.
But you can cure all that by leaving it to them after death. Don't give it to them interviews. Leave it to them after death, and now they're they get their step up in basis.
But the way to do that, if I'm understanding you right, is to put that asset in a trust and leave it to them in a trust.
No, you can just leave it to them.
You can.
Yeah, you can leave it to them outright because they when they inherit it, it's the after death part that gives
Okay.
them step up in basis. You can do it with a will.
Yes.
But when you leave it to them, they get a step up in basis if they inherit it at death.
But I'm kind of anticipating his question was also how to avoid it getting eat up with long-term care.
Sure, sure.
Okay.
Now, if the long-term care is an issue, giving it during life is not. Depending on where you are in life,
Right.
is whether it's a good thing
So
or a
if the
bad thing.
concern is long-term care, then it would be better to place this asset in
In an asset
tr-
protection trust.
asset protection trust, and then that can be left.
Right.
after
Now we
that.
still have the 5-year period when we put it in a trust. But
Okay.
if you put something in this trust like the family farm and it's an asset that you absolutely positively want to make sure it goes to my children unencumbered,
Yes.
we can still do that. We can possibly, and so if we fall short of the 5 years and we get stuck paying for a little long-term care,
Yeah.
we can do it with other assets, but this asset is in the trust and it's forever protected.
Good.
That's so.
Yeah.
There's a couple different ways. So, but I want to make sure and make sure you can give it away. People say, well, I can't give anything away during life because it triggers this 5-year period. So it doesn't mean you can't give it away.
Yeah.
You can give it away. You just need to know what comes with giving it away.
Right.
And how that fits into your circumstances. If you're 50 years old and you're just a pillar of health, and you want to, give something away, 5 years is statistically in the bag, right? No concerns. I guess something can always happen, but you know what I mean.
Right.
But, if you're 85 and you got some health issues and we're worried, it's more of a wait and see approach, right?
Yeah.
So it just depends on where you are in life when you do it, but you certainly can. Now, and again, if the question was, is it a good idea? The good idea part comes in as to why are we giving it to the child now? What problem are we trying to solve? If we're worried about long-term care getting it, I'd like to talk about that some more. It has a potential of not being a good idea.
Yeah.
If it's just to give it to him so he has it because I'm tired of working it and he works it and I just want to make sure he has it, then it's okay. It's probably not a bad idea.
You know what strikes me, and of course, it's truthful, but it's frustrating at the same time. There's not just a simple blanket answer for any one question.
Well, it's
not.
circumstance
There's,
driven.
there's not a simple blank one answer fits all. When it comes to law, it's just not.
But there's an answer for you.
Yes.
It's a circumstance driven answer.
Yes.
And the answer for you is different for someone else.
Right.
That kind of
so
thing.
that's why it's worthy of having a conversation with Stan Pierchoski.
Yeah.
And make plans to do so.
Absolutely. We can do all those things. Just let's pick the best way to do it.
Yeah, absolutely. When's your next seminar?
It is October 19th, which is a Thursday.
Oh,
It's not a Saturday. It's going to be at 1 o'clock in the afternoon. It's going to be at the Star Theater, right?
Star.
The building right next to my office on Pulaski, on the
Okay.
square in Pulaski.
All right.
It's what did I
And
just
those
say?
are free.
Yeah, October 19th, 1 o'clock at the Star Theater.
Yeah.
Call and get on the RSVP list. I'm coming up on my time. The big clock behind you tells me I've got about less than a minute.
Yeah, we
So
got-
give me a call at Pierchoski Estate Law, Pierchoski Elder Law. My phone number is 931-363-7222, or you can go to estateplanstand.com and you can contact me that way. Feel free to ask. I encourage it.
Yeah,
So-
absolutely. Estate plan stand, everybody. We do appreciate. I don't know why my start hadn't started.
But we're here every Friday from 8 to 9 for Bulletproof Estate Plan.
That's right. Let me see what this is doing. Anyway, my start hasn't started over here. But estate plan stand, everybody. That phone number again for you?
Sure, it's 931-363-7222 or estateplanstand.com.
All right. God bless everybody. And thank you, Stan, for being with us on this Friday.
Always a pleasure, Jeff.